Welcome back. A Kansas City man faces 2 criminal charges for opening fire on a teenager who showed up at his door by mistake. 16-year-old Ralph Yarl suffered gunshot wounds to the head and arm. Police say the teen wound up at the wrong address when he went to pick up his siblings last Thursday. According to court documents, the 84-year-old homeowner, Andrew Lester, told police he responded to the doorbell and opened fire, fearing Yarl was trying to break in.
Black Lives Matter! What do we want? Justice! When do we want it? Now! We don't get it!
Well, the shooting sparked protests in Kansas City calling for the shooter's arrest. Prosecutors say there's a racial component to this case. Earlier, CNN's Don Lemon sat down with Ralph Yarl's aunt, who says the charges against Andrew Lester helped the situation a little, but her nephew is still in pain.
You just cannot wrap your head around it. From being shot for doing absolutely nothing wrong to crying out for help and not being able to get help, to finally getting help, but having to do something to get that help, and then going through surgery to stay alive, coming home, and knowing that the person who did this went home and was able to sleep in his bed. And seeing your family have to fight to get the justice and attention that you should have gotten from the beginning. So there's a lot. There's a lot to process.
How do you feel now that the suspect has been arrested and charged?
A little better, but yeah, it's not as simple as turning a page.
Well, let's look at this case from a legal perspective. We're joined by defense attorney Misty Mara. Good to have you with us. This is obviously a heartbreaking story that resulted in a young teenage boy being shot twice in the head and the arm simply because he went to the wrong address. This 85-year-old white homeowner has been charged with assault in the first degree and armed criminal action. But he lives in a state where there is a stand your ground law. Can you just explain what that means and how that could be used in this case?
Absolutely, Lynda. This is such a heartbreaking story, and this young boy will likely have trauma associated with this incident for the rest of his life. But as you pointed out, this particular state in Missouri has really broad and expansive stand your ground laws. Stand your ground means that there is no duty to retreat before using force, meaning you don't have to look for other avenues or other ways to avoid a potential conflict so long as the risk is what perceived risk is reasonable, that the risk is imminent of bodily injury or harm or death, and that the force used is proportionate. So all of the things that we would think would be the normal reaction in this case, at least I would think, calling 911, calling the police, taking any other action than pulling out a gun, isn't necessarily required under the law. Further, there's another aspect to stand your ground, and it's what's called the castle doctrine. And the castle doctrine means that you don't even have to have those other elements of reasonable force or an imminent threat in order to use force against another person, because if something happens within your home. So in Missouri, that's a bit expansive, and there's actually a question as to whether or not that extends right there at that door frame into your front yard, into your property, and where that right begins. So I suspect from a defense perspective, the argument will be that this man, this 84-year-old man, believed that the victim was trying to break into his home and use deadly force. I do think that there are, from the information we have so far, there are some facts to seriously undercut that, because he will likely have to show that there was an imminent threat and there were no words exchanged, there was no weapon. So this is going to be a jury question ultimately at trial, whether or not self-defense is a valid affirmative defense to this case.
And this isn't an isolated incident. A 20-year-old woman in New York, in the state where you are, was shot and killed Saturday after going to a wrong house. She was with friends. She was looking for a friend's house in upstate New York when the homeowner opened fire, killing her. He's been charged with second-degree murder. How do you see that case playing out? Because the laws there are different.
The laws are incredibly different. So in New York, we talked about stand your ground. We don't have that in New York. There is a duty to retreat. You do have to take other non action that would not be harmful before you actually take out a gun or use deadly force. So that's number one. Number two, in New York, we do have that castle doctrine we just spoke about, but it does not attach to outside your home. The only way the castle doctrine can be invoked is if someone unlawfully enters your home. It's not going to extend to the front yard. It's not going to extend to the driveway. And it's certainly not going to extend from the door it's shooting into a car like we have in this case. So these cases, while the facts are very similar and what we expect to go before the jury, a very different analysis from a defense perspective on what's going to be successful in the courtroom based on the law.
And I'm wondering, in these various cases, how jury sympathies might play out in areas where there are higher gun ownership levels. What have you seen?
Linda, this is such a great question, and it truly is very dependent on the jurisdiction. For instance, I'm here in New York City. It is not a very gun friendly environment here. So, a jury listening to this upstate New York case is going to be appalled. They're not going to have the same reaction as this very, very rural county. Same as in Missouri. The jurors are told not to let common sense go. They're told to approach the case while still looking through the prism of their life experience. So, certainly in a jurisdiction where it is more gun friendly, or you have a lot of gun owners, you have a lot of people who own guns, a lot of people who have them in their home for protection, there's going to be a different level of understanding of the types of defenses that are being raised. That being said, they are still charged with from looking at it from a legal perspective, looking at all the evidence in the courtroom and applying it to the law. But you're absolutely right. The jurisdiction and the venue very, very much matters. And that's why we call it a jury of our peers here. It's supposed to be from the area that you're from, in that county, in that venue. And it certainly does make an impact.